SJC-11710, Commonwealth v. Michael Collins.
Thank you, Judge Gantz. I'm Ruth Greenberg for Michael Collins. I have the easiest case today, and it's always easiest to be last because then I can answer all your questions. Judge Spina had asked for a bright line rule. Here's a really good bright line rule. I didn't make it up. This court gave it in Commonwealth versus Donovan. If a witness cannot ID the defendant in a lineup prior to the trial, then we should have a bright line rule that says the witness can't then have a sandbag sudden surprise ID. If the witness can't ID the defendant before the trial, the Commonwealth needs to go to a judge beforehand and say, can I do this? And the judge in those circumstances quite rightly will say, well, why don't you arrange a full and fair lineup again? Why don't you have a different lineup? Why don't you have a procedure? And if the judge didn't say that, at least the lawyer would have a chance to argue it. But what happened here is we had a complete, effectively uncounseled identification procedure. And the fact that it occurred in open court didn't make it counseled, because this court has been perfectly clear in Commonwealth versus Donovan, reading Moore versus Illinois, that what a counseled identification procedure is one where counsel is present and where there is notice to counsel.
Counsel, may I ask how this came as a surprise to defense counsel when the identification, if I'm remembering the case correctly, was not made on direct examination, but was only elicited on redirect after defense counsel had challenged the witness? So how was that a surprise?
That's a surprise because the witness was unable to identify the defendant in a lineup before. And you can see in this case there were, for instance, Desmond Sheets, who was also given as an ID witness who had difficulty picking the defendant out of a lineup, was not asked by this prosecutor to identify the defendant in court, and in fact he doesn't. And a lawyer would have the reasonable expectation that if the witness had been unable to identify the defendant in a lineup, that she would not be asked to identify the defendant in a show-up. There isn't anything, yeah, I'm sorry, sir.
No, I'm sorry, no, finish your answer, I
No,
apologize.
I'm done. I'm asking.
No, but let's break this down a little bit. As I recall, and again, you'd be more familiar with it, on direct examination, she was asked about the lineup, and she said, I selected two photos that, was it a photo lineup?
It was a photo array.
Photo array. I selected two photos that looked like him, and number 4 and number 8 maybe, but number 4 looked more like him, all right? That was sort of the direct examination.
Yes.
And then cross-examination on the ID, and then the prosecutor asked her to explain a little bit about why she might not have been able to make a positive identification, and she said she only saw the side of his face, and the photos were from the front of his face, so she really couldn't be positive, but that, again, that number 4 looked more like it. And then he asked her, well, do you see the man here?
Judge, that's correct. And she had explained before in the grand jury and in her, that she had no side view, and the police had ample opportunity, the prosecutor had ample opportunity to arrange such a side view lineup. They chose not to do that. They didn't present this witness with a lineup. They waited until court to do it in front of a jury.
They waited until after cross-examination.
That's right. They waited until after cross-examination to make a show-up. There was no chance that this witness was going to say, oh no, it's Rosie Scapiccio. There was no way that the identification procedure in the courtroom could be fairer and more accurate than a lineup procedure at which the defense would have an opportunity to make it fair and keep it fair and to use the constitutional protections, which are not new, which were laid out in Moore versus Illinois and reiterated by this court in Commonwealth versus Donovan.
I'm trying to get to your point in trying to see this as something more than a tactical error by counsel rather than the Commonwealth's malfeasance or mischief, as you seem to be suggesting.
Judge, it's both those things. What this was a surprise to counsel. A lawyer has no expectation that a witness who cannot ID the defendant before will then ID the defendant in court.
Well, does it make any difference that it was a side view photo lineup versus a frontal facial observation during the trial itself? I mean, what if it had been a full frontal photograph and a full frontal in-court identification, and the witness says, well, the photograph wasn't good quality and it was two-dimensional. Seeing him there now with the full frontal face makes a difference.
Judge, I'm going to lean us back to Justice Link's question. It's possible that this witness could have picked this defendant out from a side-facing lineup, and the duty to arrange that lineup is not his. The
No,
duty to
I'm
arrange
addressing
that
your
is theirs.
point about the bright line rule.
Right.
Here you had a side view mugshot versus a full frontal observation in the courtroom.
But the bright-
And all I'm saying is, does your bright line rule apply when you have a full frontal photograph with a full frontal in-court identification?
Yes.
Why?
The bright line rule applies if the witness is unable. There has to be advance notice and an opportunity for counsel to argue to the judge for a more probative and less unreliable lineup. If in this case, the prosecutor had come to the court and said, I think maybe she can pick it out from a front-facing lineup, then counsel would have had the opportunity to say, well, let's do that lineup. Let's have a photo array. Let me make it fair and open and not out of one person. The bright line rule is if the witness can't pick the defendant out before, then it's got to go in front of a judge with counsel having an opportunity to argue that the second lineup should be fair and have all the constitutional protections that are guaranteed. And in answer back to, and it would be the burden on the prosecutor to make that fair lineup instead of a show-up.
So the point, I take it, is that a defendant's presence in the courtroom telegraphs to an eyewitness that the police believe he committed the crime.
There's no question. And the choice of people to choose is one. And the fact, when we were talking about the variables, the due process arguments, the fact she's seen this person's picture before leans that way also. But the prosecutor likely would not have asked the question in order to have the witness say, that's not the guy. You can draw that inference from the fact he didn't ask Desmond Sheets. But in answer, I don't want to leave without answering Justice Hines' question. It's two things. It was wrong and in violation of the right to counsel for the prosecutor to do it this way, to arrange a one-man show-up in the courtroom without notice to counsel. And the cases are clear that what's required is notice. And the cases are also clear that the reason that is so counsel can make the lineup fair, as opposed to a show-up not required by exigency. What's ineffective here is failure to object afterwards, letting it go.
So what's your position on what the Commonwealth is supposed to do, or what the limits are for the Commonwealth when the cross-examination has gone forward as it did in this particular case? Are you saying that the Commonwealth, it's too late for a lineup at that point, so the Commonwealth is limited in its redirect because it would be otherwise unfair to the
Absolutely.
defendant?
There is no rule of rebuttal which permits the Commonwealth to proceed by making an unconstitutional identification procedure because the defendant is successful on cross-examination or begins to be successful. There is no rule that rebuttal permits this. I'm sorry.
No, I'm sorry, please finish.
Yeah, I'm sorry, go ahead, you asked me.
So if if a witness, are you also saying that if a witness makes an identification of a defendant pre-trial from a lineup, is the one-on-one identification in the courtroom unduly suggestive even in those circumstances?
No, that is not my argument and not Mr. Collins' argument. I see my light flashing, I want to speak to
you may answer.
prejudice.
You may
Very briefly.
Go ahead.
If this ID is, as I say, no good, and I mean certainly to preserve this as both a federal and a state issue, if this ID is no good, this case is no good. This case, unlike what Judge Broussard did when he looked at all the different things and said each one made no difference because the other ones were there, that is an abuse of discretion. It's not an abuse of discretion meaning a misjudgment. It's a simple error of logic. If he says, this is okay, this is harmless because it's buttressed by this, and this is harmless because it's buttressed by that, but neither of the buttressers are okay, then they can't together be okay. This case, nobody heard anything after they heard Teresa Jones look at one man and say, that's the man. Nobody heard anything else in this case. This ID made the Commonwealth's case. The other things which are called IDs, they're not IDs. They're things like
You just
looked a
say
lot like-
because Laguerre, if I'm saying his name correctly, is just such a troubled witness? Is that why?
The prosecutor says you don't have to believe Pierre Laguerre. And in fact, the verdict shows that the jury didn't believe Pierre Laguerre because they acquitted on the thing for which Laguerre was a witness. The only person that was credited here was this ID, and if you credited it, which all cases say, there is nothing more powerful for a jury than a person standing there and saying, this is the man, now that I see him. And that's why that should not be allowed to occur, not never, but certainly not in cases where when the lineup is fair, the witness couldn't. And that's what we have here. No fair lineup permitted this witness to ID this person. She could only ID him in the courtroom when he was the only person there. And that's my argument.
Thank you, counsel.
Good morning again, Kaylin Campbell on behalf of the Commonwealth. I'd like to start with the bright line rule with a question that you asked, Justice Spina. I don't think it would be appropriate to adopt a bright line rule in these types of cases because factually they're all so different. I believe you asked in the Creighton case whether there should be a bright line rule as to timing, and my response to that would be no, because there's certain cases where the Commonwealth, through their investigation, doesn't know who the defendant is, such as in a DNA case where there's a hit and CODIS. So in that instance, it'd be unfair to place them in a position where an identification couldn't be made, where it's only through subsequent investigation that they learn the identity of the defendant. But turning to this case, I'd like to point out that the scientific research, both presented before the special master in the Henderson case and relied upon by the study group, specifically Professor Garrett, they note that there's never been any field research that shows that a jury places any emphasis on an in-court identification. There's never been any research that shows that they believe that evidence over other evidence. And so for that reason, I don't think that it would be sound for this court to say that jurors typically over-rely or over-believe this type of evidence.
But that's kind of common sense, though. Do we need a study for that? You're in the courtroom, there's the flag, there's the judge. It's very formal, and the witness looks at the defendant and says, that's him. So we don't need a professor of psychology to tell us how important that is, because we can understand that by common sense.
Sure, we could understand that by common sense, but under that logic, if the jury really did overbelieve and over-rely on that evidence, every case where there was an in-court identification would lead to a conviction, because the jury would place undue emphasis on that in-court identification. And that certainly isn't true, which is borne out through obviously not reported cases, because there wouldn't be a conviction, but it happens time and time again.
Could you, I'm trying to remember, I should, but the sequence here.
Sure.
Direct examination, Mr. Fredette didn't ask any questions about whether the witness could identify. And then the cross attacked, what did the cross do?
Sure. During cross-examination, there were over 12 pages that specifically attacked this witness's ability to make an identification. So then on redirect, and this certainly was known to defense counsel prior, the prosecutor asked the witness the reasons why she was unable to make an identification from the lineup, from the photo array, excuse me. So this certainly isn't a case where none of this was known to trial counsel. And my sister wants to draw a comparison between Desmond Sheets, a witness who was not asked to make an in-court
He's the
identification.
upstairs-
He's the downstairs neighbor who goes upstairs, yes. But I think that you can look at the juxtaposition of the cross-examination of Desmond Sheets and the cross-examination of Teresa Jones to understand why the prosecutor did what he did. Desmond Sheets is asked maybe in total not even four, around 3 pages of questions having to do with his identification of the defendant. Now, my sister in her reply brief takes issue with my classification of Desmond Sheets's selection of the defendant as an identification. I would disagree with that. The evidence was that
It's a small, slim man? Is that what he said?
no, he had a photo array. He picked the defendant's photograph out, and specifically on transcript 5, page 209, he said that he picked that photo out because the person depicted in the photo looked like the guy who did it. More than that, though, trial counsel in this case referred to Mr. Sheets' selection as an identification. She did so during cross-examination, and an example of that can be found in volume 5, page 208. And she also argued that to the jury during her closing argument, which can be found in volume 12, page 97, in which she said that Mr. Sheets came into court and that and I'll quote that, he specifically said, that's him, in reference to the defendant. So I don't think it was a question at trial, and I don't think it's unfair to classify Mr. Sheets' selection of the defendant in the photo array as an identification.
But now I'm very confused.
Sure.
I take it evidence of the photo identification was put before the jury.
It was.
Okay.
It was. Just in my sister's reply brief, she says that I unfairly call Mr. Sheets' selection as an identification. I just want to address that with the court.
So evidence of the non-identification by Ms. Jones was put before the jury?
Certainly, yes.
And then it was the subject of a great deal of cross.
Yes.
And then the prosecutor went
Asked
through
her.
the reasons why
Yes.
she couldn't, and then asked her if she saw the person in court. Is that right?
Correct. Then there is recross, and I think this is important because it goes to the prejudice, the prejudice evaluation. On recross, trial counsel again asked this question about her inability to make an identification, and specifically, she got this witness to say that she didn't actually see the face of the person who came into her room, and the jury certainly heard that evidence. So any in-court identification was certainly equivocated by this extensive recross examination, which ends with trial counsel asking a question akin to, and you didn't even see the guy's face, correct? And the witness saying yes.
So, again, I don't remember this, but in terms of the study group's recommendation about in-court IDs, the study group suggests that it could come in on redirect, right?
Correct.
Are they in different circumstances in this kind of case? I just don't remember.
No,
this.
the study group, unfortunately, that specific recommendation doesn't come with much explanation. It simply says that it would be allowed in the judge's discretion on redirect. So it certainly would be a question of whether the judge would have abused his discretion in allowing it here. There was no objection to it, and arguably trial counsel used it to her benefit in the recross examination. But again, it's our position that that per se categorical ban on in-court identification shouldn't be adopted by this court, especially where it seems to encompass any identification and not just an identification of a stranger of another stranger. And certainly, there's nothing in any of the scientific studies to show that someone who has familiarity with a perpetrator of the crime, that their identification of a defendant would be unreliable.
But what's the jury supposed to do with this particular ID, since I gather there was no instruction concerning in-court ID at the close of the case, was there?
There was an instruction concerning, the model instruction was given as to eyewitness identification, along with a mistaken but honest belief in misidentification. There also was an additional jury instruction that was given by the judge, and this can be found on volume 12, pages 210 to 211, in which the judge said, and I quote, "Some studies have suggested that witnesses are more likely to make an incorrect identification when they observe the perpetrator under stressful circumstances." He went on to explain, to tell the jury to consider the credibility of each identification witness in the same way as any other witness, consider whether he or she had the capacity and the opportunity to make a reliable observation on the matter covered in his or her testimony. So there certainly was an instruction given to focus the jury as to the fact that this may or may not be a reliable identification, and that stress, a certain estimator variable, may or may not affect the ability of a witness to make an identification.
Was there a motion to strike the in-court identification at the end of the recross examination?
No.
Could there have been? I mean, should that, if there had been such a motion, should it have been allowed?
I don't believe so, because I think the question is whether this witness, so the studies couch it in terms of reliability, but I think reliability actually isn't a good word. I think the question is whether this witness had the ability to make an accurate identification.
Based on a face that she never saw.
That's correct. Had that come down at their motion to strike, a judge could weigh whether that was just a response in frustration to trial counsel's question, or if the judge actually believed that the witness didn't see this face. I would suggest that the photo array itself suggests that the witness did see the defendant's face, because she was able to narrow it down to two individuals, and she did point to the picture of the defendant and say, that looks more like the guy who did it. In my remaining few seconds, I again want to turn to the prejudice prong and say that it's not just that Judge Broussard looked at these factors. He looked at the evidence as it corroborated the identification of the defendant as the perpetrator of this crime, which included circumstantial evidence.
Can I ask you one question? You
Sure.
suggest, I think it's in this case, that you suggest that pretrial stick with suggestiveness as the sort of key to whether there would be a hearing on a pretrial hearing on identification.
Correct. Keep the
But-
motion to suppress.
But at trial, if a defendant challenges or seeks to can move in limine to do so, in which case the burden would be on the Commonwealth to establish that it was reliable identification, correct?
That is the basic, that's the gist of it. I would say that the defendant, first the burden would be on the defendant to raise it in the way that fits with Rule 13, and in line with the study group's recommendation. In order to obtain a hearing in that case, like the study group recommends, and this is on page 110 of the report, it would have to be an uncorroborated witness identification. And in that instance, where it's an uncorroborated witness identification.
What does that mean, uncorroborated, in this context?
In this context, I think it would mean that the eyewitness identification of the defendant is the really only evidence that supports that he was the perpetrator of this crime.
So in this case, I was trying to figure out how that would work in this case. Would you say that the defense counsel didn't know that the prosecutor was going to do what he did?
Well, I would say where you have an out-of-court identification, if a defense counsel is worried that the Commonwealth would offer this type of identification, they should move in limine to exclude a witness from doing that if they have real concerns about that witness making an identification. Now, always, things come up at trial, evidence comes in a different way. prior to making an identification, where the prosecutor in this case said, and can you identify the defendant here today, it would be on the defense counsel to object, which she elected not to do here. And as you can see, because she had an effective recross examination, so that certainly was a tactical decision that didn't end up depriving the defendant of any substantial ground of defense.
All right, thank you.
Thank you.
We'll take our break right now.